America. My name is Greg Brown. For decades, I've been serving a life sentence in Washington State for two murders I had nothing to do with. My prosecuting attorney lied to my jury several times and even covered up the fact that the state's number one witness was in an insane asylum being treated for delusions and psychosis the whole time. Prison guards have tried to harass me to death and shut me up about this, so I sued them without an attorney, and I wanted some money. When I tried to get legal help, this piece of shit attorney ran off with my money. And when I sued him to get my money back, this piece of shit Washington State judges lied, covered it up, and stopped me from suing him because this piece of shit attorney was also a judge like them, a municipal court judge. They cover up for each other. I want to tell my listeners the details so that everyone will know who this attorney is and who these judges are. And know I'm telling you the truth and see how these lawyers and judges are lying pieces of shit. They need to be made accountable. This attorney's name is Lawrence Freedman. He lives in the Port Angeles area. I hired him to get a formal answer to a simple question. Am I serving a life sentence or am I serving life without parole? The reason why I needed this question answered was because the Department of Corrections has me serving life without parole, even though my judgment sentence only says life. My judgment sentence don't say nothing about life sentence without parole. I found Freeman's name in the yellow pages back in the year 2015, and he said he was interested, and he said I have to send him $3,000 to retain him before we could talk any further. So, on June 11, 2015, we signed a contract saying he would charge me $250 an hour, but that he would not charge me anything until after he's done 13 hours work on my case. So I sent him the $3,000 directly from my prison account. Now, after a while, I knew something was fishy when he visited me and started saying I need to send him all of my papers, including trial transcripts and any and everything else that had nothing to do with what I hired him for. And he wanted to charge me thousands of dollars just to say he read all my papers. But during this visit, he smelled like alcohol and he looked like a drunk. He looked like somebody who was living in his car, been divorced 3 years, paying 3 alimonies. It seemed he was desperate for money. After our visit, he sent a letter to the parole board asking them to give me a parole hearing because my judgment sentence only says life. But meanwhile, I told him that I'm not going to pay him to read my papers that have nothing to do with what I hired him to do for me. He got mad and said he can't work like that. So I told him, hey, man, we'll just kick rocks and send my money back. Man, this punk threw a fit because he had already spent more money. But he hadn't even done 13 hours work yet. He said he did so much work for me, 12.6 hours of work to be exact, to where I now owe him money. He said I owe him $150. And he made up a bunch of stuff to charge me for. Like, for example, he charged me $250 an hour just because I called his phone number and asked him if he's an attorney. Now, can't no attorney be billing you for calling him and asking you if he's an attorney? Charging me for that violated his ethical standards and also violated the Washington State Consumer Protection Act. He also claimed he did things that I could not verify. Clerical work, like read my letters, organizing my file, moving my file from one cabinet to another. All this kind of stuff added up to over $3,000. I figured he must have been drunk. He must be drinking because our written contract said he would not use any of my money until after he had done 13 hours work. And according to him, he did not do 13 hours work. As long as he was lying and making things up, man, he should have at least lied and said he did more than 13 hours work. So yeah, I thought he must be drunk. I filed a malpractice complaint against him in the Clallam County Superior Court, number 18-2-00459-1 judge in the area refused to even hear my case because they could not be fair and impartial in this lawsuit against a fellow judge. So this Jefferson County Superior Court Judge Keith Harper got on my case saying he could be fair and impartial. He lied. In this malpractice complaint, I had 25 claims designated as claims A through Y. I mentioned that Freedman said he wrote a letter to the parole board, but that I never even received a letter or received any proof on whether or not he really wrote this letter. So, in order to prove he really wrote this letter, Freedman said he got a response from the parole board. Now, wait a minute. What a revelation. Why didn't he tell me about the parole board's response before now? The law says when you pay an attorney to write a letter for you, any response to that letter that you paid for is your personal property, and the attorney must give it to you because you paid him to get it already. So now I needed to amend my complaint in order to add the fact that Freedman refused to tell me about the parole board's letter response to this letter that I apparently paid him for. On June the 27th, 2019, Freedman hurried up and filed a motion for summary judgment against my claims A through Y in my initial original complaint. On March 4th, 2019, I filed a motion to amend my complaint to add this claim Z about Freedman refusing to tell me about the parole board's response to my letter. And on March 8th, 2019, Judge Harper granted my motion to amend. Now listen, while granting my motion to amend my original complaint, Judge Harper said, and these are his own exact words, quote, if you end up having to request a continuance, hold on there a minute. Stop right there. This is very important for everyone to see this. I don't want this to fly over anybody's head. Judge Harper starts talking about a continuance. Remember this is really important, which is the same thing as an extension. At this hearing, nobody said anything about any continuance. I didn't say anything about a continuance. Freedman didn't say anything about any continuance. Harper is the only one talking about a continuance. Remember this, because I'm going to come back to it in a minute. Okay, now, let's move on. So when he granted my motion to amend my original complaint, Judge Harper said, quote, if you end up having to request a continuance on the March 2nd hearing or on any hearing, then you have a right to file a motion and any supporting papers to request that. Okay? I haven't made a decision about any future continuances. If either side needs any additional time for any reason for a postponement, an appropriate motion for continuance should be filed with any supporting documentation to justify it. Because I understand now that both defense motion for summary judgment may have to be revised to take into account this additional claim. One way or another, that was going to happen. So I'm choosing to do it this way. Unquote. It sounds like this judge is babbling a little, trying to say something and trying not to say something. Maybe even speaking in code to Freeman's attorney. I later researched this subject, and I found out that all of the law, every single court decision on this subject says my original complaint no longer exists because the original complaint is completely replaced by the amended complaint. So now, because Freedman's motion for summary judgment is against my original complaint that doesn't exist anymore, Freedman has to withdraw the summary judgment motion against my non-existent complaint and then refiled it against my amended complaint. This is why Harper babbled, quote, defense motion for summary judgment may have to be revised to take into account this additional claim, unquote. Now, what additional claim is he talking about? It's claim Z against my amended complaint. That's the additional claim. Remember, my original malpractice complaint had claims A through Y, and my amended malpractice complaint restated claims A through Y and also added claim Z on top of that. So instead of babbling, beating around the bush and speaking in cold, why didn't Judge Harper just order us to refile our papers? The only reason why I could think of is because he was thinking about maybe getting me to ask for continuance to refile my papers and then denying my request and saying I was supposed to do that, and then using that as an excuse to throw out my complaint against his colleague, federal judge Freedman. Now, if you think this sounds a little far-fetched, to any of my listeners, then let me tell you something. It really should not, because this is exactly what Judge Harper ended up doing. My objection to Freedman's summary judgment motion against my original complaint obviously was already due. Judge Harper obviously knew this and knew we needed continuance to refile our papers. He was the one talking about continuances. Freedman needed a continuance to refile his motion for summary judgment. I needed a continuance to file my objection. So I waited for Freedman to withdraw his summary judgment motion against my original complaint and to request a continuance and refile his summary judgment motion against my amended complaint. But he never did. And Freedman didn't do anything. Now, remember I suggested it looked like somebody was speaking in code. Well, because I already knew that, legally speaking, Freedman's summary judgment motion was legally invalid and non-existent, then I knew by now somebody is playing a sick game here. Maybe Freedman and the judge were playing a sick game together. So I decided to be on the safe side and to do my part. I figured they was trying to keep me asleep and prevent me from doing what I had to do and then blame me for everything. So instead, I did my part, even if Freedman didn't do his part. I requested my continuance to object to Freedman's summary judgment motion, and I converted my objection so that it applied to my amended complaint, which covered claims A through Y and claim Z. So I did what I was supposed to do. I've done my part. I don't know what they're going to do, but here's what they did. On March 28, 2019, for the sole purpose of stopping me from objecting to Freedman's summary judgment motion, this judge denied my motion for continuance and refused to consider my objection. Instead, Harper granted Freedman's summary judgment against my non-existent original complaint, claims A through Y. Now think about this, people. This is crazy and not even possible by law. You can't make a judgment on a complaint that doesn't exist. On April 23, 2019, I tried to file a notice of appeal challenging this March 28, 2019 judgment, but the clerk of the Court of Appeals on July 15, 2019 rejected my notice of appeal by saying that Harper's March 28, 2019 order dismissing claims A through Y was not an appealable, a final appealable order. It was partial summary judgment order, which is not a final appealable order. Because of this, I cannot appeal until my claim Z gets resolved. An open case. Nearly 2 years later, I really didn't care about the other claim. It was 2 years later, it was July 9, 2021, Judge Harper granted Freedman summary judgment against my claim Z of the amended complaint. In granting the summary judgment, this summary judgment, okay, so let's pause again and let's go over this. Harper dismissed claim Z from my amended complaint, and he said there are no remaining claims in this case. But what about my claims A through Y in my amended complaint? Are not these claims A through Y remaining issues in this complaint? Well, remember I said somebody was playing a sick game. They magically took Freedman's summary judgment motion off of the original complaint and somehow magically transposed it to my claims A through Y on my amended complaint without requesting a continuance and without redoing their motion. I say magically because this summary judgment motion clearly says it's against my original complaint. It says nothing about my amended complaint. And remember, they needed to request a continuance and revise their motion so that it would be against my amended complaint and not against my non-existent original complaint. Remember, Judge Harper said, quote, if either side needs an additional time for any reason for a postponement, an appropriate motion for a hearing should be filed with any supporting documentation to justify it. Because I understand now that both defense motion for summary judgment may have to be revised to take into account this additional claim one way or another that was going to happen. Unquote. He said that, not me. The judge said that. So, instead of doing it the right way, they just magically and secretly made it happen by skipping over all of the process and instead magically putting Freedman's summary judgment motion onto my amended complaint without requesting a continuance and without revising their summary judgment motion to apply it to my additional claim C. And the reason why they did that was so they can deny me my continuance and refuse to hear my objection. That's why they did that. Now remember, Harper said there are no remaining claims in this case. The only way there could be no remaining claims in this case would be if Harper's March 28th, 2019 partial summary judgment order against claims A through Y of my non-existent original complaint is considered to be proper. If that order was not proper, then claims A through Y were never legally dismissed, and they would therefore still need to be resolved. You don't have to be a lying judge or a lying lawyer to see that the March 28th order was a sham and had no legal validity because it was applied to a non-existing complaint. That doesn't even sound right. All you need is fundamental basic common sense. My claims A through Y, which this sham March 28th order purported to dismiss, still legally remain to be decided in my case. On July 26th, 2021, I filed a second notice of appeal. This appeal is in the Washington Court of Appeals, number 56025-9-Roman numeral 2. This is regarding the July 9, 2021 final order dismissing my claim Z. I had to pay $290 for filing fee for this appeal, over $500 for copies of the record, and $200 and then watch the Supreme Court later. Now, in my initial appeal brief, I argued that the superior was wrong for granting summary judgment to Freedman against my void, non-existent original complaint on March 28, 2019. I argued that my amended complaint, adding new facts and adding a new cause of action, rendered Freedman's motion for summary judgment moot with regards to my original complaint. In order to cover all of this up, the Court of Appeals denied my appeal by stating I did not appeal the court's March 28, 2019 summary judgment order. Now, some people, I don't know, that might sound right because I appealed. Remember when I said I appealed? Hold on a minute, where is this? Remember I said I appealed the July 9th, 2021 final order dismissing my claim C. And the Court of Appeals says, well, I didn't appeal the court's March 28th, 2019 summary judgment order. And because of this, I cannot talk about the March 28th, 2019 summary judgment order. That was the order where he messed up. Well, the judge lied. Let me show you why. The Washington State Supreme Court decision in Fox versus Sunmaster. This is important for me to cite the page numbers. It's at 115, Washington 2D, pages 498 and page 509. That is the Washington Supreme Court showing that these judges in the Court of Appeals straight up lied. Fox versus Sunmaster says, quote, the general rule set forth in Rules of Appellate Procedure 2.4a says the court will review at the instance of the appellant the decision or parts of the decision designated in the notice of appeal. A partial summary judgment order is part of the decision ultimately rendered in the case. Additionally, Rule of Appellate Procedure 2.4b expressly permits the appellate court to review any earlier order or ruling, including any appellable order, regardless of whether it is designated in a notice of appeal, if it prejudicially affects the decision designated in the notice. Depending on the nature of the case and the relationship between the parties' claims, a partial summary judgment order can prejudicially affect every order entered thereafter, and often will plainly so affect the judgment that ultimately disposes of the case. Unquote. And that's the Washington Supreme Court. So remember, I said earlier, the clerk of the Court of Appeals refused to allow me to appeal on April 23rd, 2019, because the March 28, 2019 order was a partial summary judgment order that did not dispose of an entire case since Claim Z was still pending, right? Well, Fox versus Sunmaster clearly requires the court to review this partial summary judgment order where it says, general rules set forth in Rules of Appellate Procedure 2.4a says the court will review at the instance of the appellant the decision or parts of the decision designated in the notice. A partial summary judgment order is part of the decision ultimately rendered in the case. Now, I know for most people, law is really hard to understand. It's complicated. So I'm going to explain it to you in a way that may make it more clear. Imagine you have a court case and there are 100 motions and 100 decisions made in those motions in your court case. And ultimately you lose the case and you file an appeal. you have to file a notice of appeal. In your notice of appeal, you of course have to say what it is that you're appealing. That you're appealing the judge's final order where the judge says you lost. But listen, you don't have to list all 1,000 motions and all 1,000 times the judge denied all of your motions and your notice of appeal to say you're appealing those. All you have to do is say you're appealing the final judgment. And after that, then you can talk about all the other 1,000 motions that were made during your case and all the 1,000 motions that the judge denied. Everybody knows this who practices law. This is done every day. Washington State Rules of Procedure says, quote, the appellate court will review at the instance of the appellant, the decision or parts of the decision designated in the notice of appeal. Remember, it says parts of the decision designated. And the Supreme Court decision in Fox versus Sunmaster is a decision by the Washington State Supreme Court that provides clarity for what this rule means and how it applies in a case like mine, in which there was a partial summary judgment order entered earlier during the course of the case and before the case was finally disposed of. The rule says that the court will review parts of the decision designated in the notice of appeal. The decision designated in my notice of appeal was Judge Harper's July 9, 2021 summary judgment final decision in my case. And like I explained earlier about being able to bring up everything in the case, Fox versus Sunmaster explains that my partial summary judgment order is a part of the decision designated in a notice of appeal that can be talked about when I appeal for subsequent final summary judgment order that ultimately disposed of the case. For example, the July 9th order that I appealed in my case. Terms, Freedman line and the Court of Appeal judges, Jackie, Judge Lee, and Judge Cruiser all straight up lie along with Freedman by saying the Court of Appeals cannot listen to my arguments about the October 28, 2019 partial summary judgment order, and saying this because they didn't want to hear my objection. Now, the reason why they didn't hear my objection is because then they would not be able to rule in my favor, because they will obviously claim a contract that I signed with this attorney was that he wouldn't do anything with my money until after he put in 13 hours of work. But he filed a statement saying he only put in 12.6 hours of work, which means he got to give me my money back. He loses. So they had to refuse to allow me to object. All these people knew that a partial summary judgment order can automatically be argued against in any appeal, because the partial summary judgment order is part of the decision ultimately rendered in the case. But the only way, okay, what's that? These arguments, the Washington Supreme Court. Sorry, I had to pause there. I was looking for that number. But the Supreme Court did not act without making any specific comments about anything. They just said denied, and that was it. Now, on top of everything else that I've already said, there's another reason why the appeals court was supposed to hear my arguments. Remember, Judge Harper said there are no remaining claims in this case. And I said the only way there could be no claims remaining in this case will be 2019 partial summary judgment order against my non-existent original complaint was proper. If that order was not proper, the claims A through Y would still have a properly dismissed, and they would still exist and still need to be resolved. Well, this means the appeals court would assume March 28, 2019 partial summary judgment order was proper because it can say before it can say there are no remaining issues in this case. Fox versus Sunmaster required the appeals court to decide this issue by saying Rules of Appellate Procedure 2.4 expressly permits the court to review any earlier order ruling, including an approval order, regardless of whether it is designated in a notice, if prejudice the decision in the notice. A partial summary judgment order can strictly affect every order after, and often will can be so affect the judgment that ultimately disposes the case. Now, the term prejudicially effect is a legal term which basically means it created a situation to cause harm to me. Remember, appeal the July 9, 2021 order, the March 28, 2019 order, claiming to have disposed of my claims A through Y, is the reason why the July 9, 2021 order says there are no remaining claims in this case. Because this Rules of Appellate Procedure 2.4b expressly permits the appellate court to review this March 28, 2019 order. So this is the second reason why Fox versus Sunmaster required the Court of Appeals to hear my argument. In my argument about Judge Harper being wrong for granting Freedman summary judgment against my non-existent original complaint, I cited numerous cases saying you can't do that. I cited Flute versus Capital 7 Management Services Company versus Richmond at 106 Washington 2D 614, which says amended complaint replaced the original complaint. I cited Skidboard versus Pack Creditors at 18 Washington 2D, page 157 and 170, which says the amended complaint constitute an abandonment of the original complaint and the action rests now on the original complaint. I cited Ennis versus Rain, 49 Washington 2D, page 284, where it says where an amended complaint added a new cause of action, it was the action upon the amended complaint. I cited Seeley versus Gilbert, 16 Washington 2D, page 611, page 616, stated that the trial court cannot issue judgment on an issue made in an original complaint after the amended complaint was filed. Versus Creek Bank at 5 Washington 2D, page 554 and page 593, which says a motion to dismiss that was made against an original complaint must be refiled to address the amended complaint. I cited Her versus Her at 35 Washington 2D, page 164, and pages 166 and 167, that says the filing of amended complaint abandons the original complaint and rests the entire case on the amended complaint. Now, Freedman's attorney argued that those issues might not really apply because they were filed at different times and at a different point in my history, 20 and 30 years ago and stuff like that. And but they did not explain legally why the court should not apply those cases to my case, and he did not cite any case, not one case, that he believes should fit my situation. Did not cite a single case saying the judge can dismiss my case by dismissing my original complaint after I filed an amended complaint. No cases. They were strained. they cited two cases in their entire brief. And two of those cases were the cases that I cited, them saying, hey, well, Judge, you shouldn't really go with that. And they didn't address the other 5 or 6 or 7 other cases. But those are the only cases that they cited were our cases. And they never cited any case to argue their point. So, at page 7, I cited cases Beal versus City of Seattle at 134 Washington, D, page 769 and page 777. And I cited another case, Caruso versus Local Union number 69 at Washington, 100 Washington, D, page 343 and 349. And I cited the third case, Adams versus Allstate Insurance Company at 50 Washington 2D, pages 6459 and 672, which all say that the state court should use federal cases to determine my issue because Rule 15 governing how amended complaints are to be handled is exactly the same as the federal Rule 15 governing how amended complaints are to be handled. Then I cited many federal cases at pages 7 to 8 that are all precisely on point with my case. I cited Furtick versus Bonzillet at 963 Federal Reporter 2D, page 1258 and 1262, which says that after amendment, the court should treat original complaints as non-existent. I cited Forsyth versus Humano at 114 F3, page 1467 and 1474, which says an amended complaint supersedes the original, the latter being treated as non-existent. I cited Spears versus Arizona Regis, 373 and 2D, page 893. Precedes the original. I cited King versus American Power Conversion Company at 347 F3D, pages 11 and page 16, which says a plaintiff's amended complaint completely supersedes his original complaint, and thus the original complaint no longer performs any function in the case. I cited 6 Charles Allen Wright, Arthur R. Mile, and Mary Kate Kane, Federal Practice and Procedure, subsection 1476, second edition, 1990, where it says, once an amended complaint is interposed, the original complaint no longer performs any function in the case. And I cited Young versus City of Mount Rainier, 283, Fed 3D, page 567 and page 573, which says an amended pleading rendered a pending motion to dismiss your initial complaint moot, non-existent. And I cited DeJesus Baltiera versus West Virginia Board at 253 Fed Supplement 2D, page 9, where it says an amended complaint rendered a pending motion to dismiss the initial complaint as moot, non-existent. What these last 2 cases mean is that, as applied to my case, Freedman's motion for summary judgment was moot and non-existent. It didn't exist anymore because it was attached to my non-existent initial complaint. So why are the judges saying right now I don't have a case when legally my case is still there because they dismissed my case on a bunch of non-existent bullshit? Neither Freedman nor any court ever said anything or commented about any of these federal cases or federal authorities that I cited. They just pretended I didn't cite them. About this Young versus City of Mount Rainier case, the person being sued in that case had filed a motion to throw out the original complaint. The court ruled that the motion to throw out the original complaint itself was moot because there was an amended complaint. And this is exactly what happened in my case. Freedman filed a motion for summary judgment against my original complaint that was moot. And so Freedman's motion was also moot and non-existent. Now, in the course of my entire case, neither Freedman nor the courts ever cited a single case to support their granting of any judgment against the original complaint after I filed an amended complaint. Not a single case. Think about this. They did some stuff that's never been done before. And no case out there says they can do it. So how did they do it? They did it, man, because this is a secret and they don't expect anybody in America to even know about this. They just did it because ain't nobody gonna know about it. But I'm letting everybody know about it. Because they did not cite a single case to support what they did, and because they completely ignored all the cases that I cited, wouldn't it be fair to say they lied in order to cover up my lawsuit against their fellow judge attorney, Freedman? I mean, we might be able to look at it differently if they had cited just one case saying they could do what they did. But they didn't cite anything because they couldn't. Even though I cited all these cases and made all these arguments, these Washington courts just kept making excuses after excuses, talking about they can't hear my arguments, even though Fox versus Sunmaster clearly says they can hear my argument. And they never said anything about Fox versus Sunmaster either. They couldn't. They acted like I never even cited Fox versus Sunmaster. If you read what they're talking about, you wouldn't hear anything about what I said. They wouldn't hear anything about Fox versus Sunmaster or anything else because they ain't say nothing about that. All they did was made a bunch of stuff up and ruled based upon the stuff that they made up and didn't even listen to what I'm talking about. These are some of the reasons why I need an attorney to present my issues regarding my false imprisonment. If I don't have an attorney, man, they're just going to lie about what I said and lie about what the law says in order to deny me what I'm asking for. Those of you who have listened to my segment regarding my 41 years of innocence are aware that the state of Washington never investigated my case. They never investigated to determine if there was any evidence that could suggest that I'm innocent. They never looked into it. They just rushed to convict me because it was election year. My appointed attorney didn't bother to investigate or even try to defend me in any way whatsoever. Recently, I hired a private investigator who uncovered documents showing the state's main witness against me was committed to a insane asylum, being treated for delusions and psychosis while testifying against me. For those reasons, his testimony would have been inadmissible as a matter of law. But they all managed to cover all of this stuff up until now. Now I need more money to pay this private investigator. I've spent over $1,000 on this malpractice case against Freedman. And of course, Freedman himself ripped me off my $3,000. How long and how low and dirty do you have to be in order to rip someone off in prison who's fighting for his life in a situation where the state never gave me an attorney to represent me and never investigated my case? The state still owes me an attorney and owes me a proper investigation. Yet, when I try to get my own attorney and I try to do my own investigation, I get ripped off of my money. One might think